Hello, everyone, and welcome to One Civil Law. And for tonight's stream, we are turning our attention once again to the Karen Read case, more specifically with respect to federal court. Karen Read, as I'm sure you're aware, is on trial for the murder of her boyfriend. There has been a question relating to the jury and what they did or did not do, and exactly what legal effect that may or may not have, specifically with respect to the due process clause of the U.S. Constitution. She has applied for federal habeas relief, which is a fairly limited and constrained kind of review. The federal court will really only intervene in the event of clearly established federal law, which unfortunately has to be quite clear. So not necessarily a great posture to be in, but those are the rules. And we reviewed her initial complaint that she filed in federal court, and it actually looked a little bit better than I initially gave it credit for. There was a First Circuit precedent in particular that looked pretty good. And it looked very close on the issue of the judge not sufficiently exhausting all the alternatives to a mistrial before declaring a mistrial, that her decision was done in undue haste. So that looked pretty good. But there was an issue relating to her failure to object, which they call consent, but basically boils down to the same fundamental issue. If you don't object, you lose it. You use it or you lose it. And she arguably did not object, even though she had potentially the opportunity to do so, at least in the 30 seconds it took the jury to get to the jury room after the judge said, I'm going to declare a mistrial, before, of course, she formally dismissed the jury. In any event, we are going to pick up with the state's response to Karen Read's petition. We picked up the response at page 10 of the response, the first 9 pages being devoted to a history of the case, but you guys already know that. We don't have to go over it again, so let's go ahead and get started. This pretrial challenge is governed by the general habeas petition provision of U.S. law. The First Circuit's section 2241 precedent instructs that to the extent this petitioner may be presently in custody for the purposes of federal habeas relief, it is not pursuant to the court's ruling, but rather it's because of any state-imposed restriction on her liberty while she's awaiting retrial on existing indictments. The petitioner is subject to such restrictions. She remains admitted to bail and must comply with certain pretrial conditions of release inapplicable to the public generally. That suffices to meet the in-custody requirement of law. Fair enough. Fair enough, right? She's in custody enough for the purposes of habeas. And whether she's in custody enough for other purposes could get interesting, incidentally. You know, just how restrictive is her bail, for example, could get into issues about whether or not she's in custody. So house arrest may or may not qualify as being in custody, depending on what procedure we're under and what statute we're under. How fun. But at least for this moment, we think that she's under custody enough for the purpose of federal habeas review. Cool. Great. Having obtained a review on the merits of her claim by the Supreme Judicial Court of Massachusetts, she's exhausted her available state interlocutory remedies, and her claim is one of double jeopardy based on alleged successive prosecutions. Her resort to federal habeas relief need not await retrial and conviction on the 2 challenged indictments, and they cite a First Circuit precedent for that proposition, which the defense also cited. Okay, cool. So they seem to be of the opinion that the federal court can hear this and perhaps even should hear it, which seems like a slightly odd posture, but okay. So they think the federal court has power. I was like, okay, I'm not 100% sure they necessarily do. Habeas relief is constrained. There's a lot of cases saying the federal courts want to abstain, particularly as it relates to live state level proceedings, but perhaps this is an exception to that rule. So it's like, okay, maybe the federal court will actually get to the merits. That'd be cool. All right, let's go. Anyways, standard review. On review under section 2241, this court must defer to the Supreme Judicial Court findings of fact, but must undertake a plenary review of the court's resolution of issues of law, which of course they do. We're in federal court on a federal law. So of course it's de novo with respect to the legal issue. Because, obviously the federal court is the authority on what federal law is. States can certainly do their best, but the federal courts are the ones that determine federal law, just as surely as states are the ones that determine state law. So no surprise there, de novo on the law. Cool. In conducting the plenary review, however, the court is also bound and must accept the Supreme Court's interpretation of Massachusetts law, which also is true. We're similarly bound by the state court construction of its state statute and other issues of state law. 100% true. I have said this many times, and I will continue to say it again. Only the Supreme Court of Massachusetts can determine what its own state law means. The federal courts have no power, zero, ultimately to determine what the state court's law means. Now, sometimes they'll try to guess when they have to fill in a blank, and incidentally, other states will do that too. So if I'm suing you in Michigan, but I'm suing you under a California law, which can happen, right? The Michigan court will apply California law, and they're going to do their best. And if there's a gap, they're going to guess as to what California would do based on its own precedents of California. So they're going to try to put themselves in the mind of a California judge and try to do their best. But of course, in the end, only California can be the judge of its own state law, even though they're going to try. And so just as surely here too, only Massachusetts is the judge of its own law. So the federal court must take the state level law and rules as understood by the state Supreme Court as a given. The federal courts they have no power to adjust state level understanding of state level rules and laws. All the federal court can do is say, given that it's a violation of federal law. That's what the federal courts do. Fantastic. As a matter of federal constitutional law, the trial judge exercised sound discretion in declaring a mistrial based on the jury's deadlock. Okay. A mistrial premised upon a judge's belief the jury is unable to reach a verdict has long been considered a classic base for a proper mistrial and poses no double jeopardy bar to retrial. Well, I mean, that's certainly true as far as it goes, had the court considered everything, right? So the problem isn't necessarily that the court in the end picked mistrial. That isn't necessarily the problem. The problem might be that the court did not give sufficient consideration to the alternatives, even if that consideration was literally the attorney saying it and then the judge literally saying no. That might be sufficient, right? It doesn't require much consideration, but it might require something, and perhaps not here. So yes, mistrial is a valid option, and in response to a deadlocked jury. And if the judge had considered all the options, even if for half a second, and then said, no, not so much, maybe not, but that isn't clear that that's what happened at all. The decision to declare a mistrial because of a deadlocked jury is entrusted to the trial court's broad discretion and accorded great deference on review. Typically, that's true. In Renico, the court reiterated that the reasons for allowing the trial court to exercise the broad discretion are especially compelling in cases involving potentially deadlocked juries because the trial court is in the best position to assess all the factors which must be considered in making a necessary determination whether the jury will be able to reach a just verdict if it continues to deliberate, and absent such deference, trial judges might otherwise employ coercive means to break a deadlock, thereby creating significant risk a verdict may result from pressures inherent in the situation rather than considered judgment of all the jurors, which, I tend to agree with as well, right? Especially once that deadlock instruction is given, ma'am, right? Whether we call it an Allen charge or we call it a Tui Rodriguez charge because we don't want to be like the other children and we want to give it a special name. Either way, once you give that instruction, like we all know what's happening, right? It's like either the jury's coming back with a verdict or not. And either way, everyone except perhaps the defendant is going home. The defendant may or may not be going home depending on what the jury comes back with, but everyone else is going home. So we all sort of know what's up here. But that being the case, however, there might be other options, even if the answer is no. So, maybe you need to consider it. In addition, and notably for the purposes of this case, the court went on to reaffirm what is not required as a matter of federal constitutional law in exercising that broad discretion. Okay. We have expressly declined to require mechanical application of any rigid formula when a trial judge decides whether jury deadlock warrants mistrial. I mean, fair enough. I mean, like many things in law, it isn't necessarily A plus B plus C. There are many factors to consider, and it's not necessarily mechanical. But, you still might have to do something. We've also explicitly held a trial judge declaring a mistrial is not required to make explicit findings of manifest necessity, nor to articulate on the record all the factors which inform the deliberate exercise of their discretion, which is true, fair enough as far as it goes, and tends to be true, generally speaking, on an abuse of discretion analysis. The judge doesn't necessarily need to say why they're doing something. And the Court of Appeals will go out of their way, typically, to find a reason, any reason that makes any sense, because they're going to defer to the trial judge because that's what they're supposed to do. So basically, they're like, would any judge do this under any circumstance? Is there any reason it makes sense? And only if there is no reason it makes sense will they typically intervene. Right? So either it makes no sense or the option was batshit. So basically one of those things. Short of that, the Court of Appeals does not tend to interfere. Fair enough. And we never required a trial judge, before declaring a mistrial based on jury deadlock, to force the jury to deliberate for a minimum period of time, to question the juries individually, to consult with or obtain the consent of either prosecution or defense counsel, to issue a supplemental jury instruction, or consider any other means of breaking an impasse. I mean, again, not necessarily mechanical. Not necessarily mechanical. So none of these things are necessarily required. They're not necessarily required. Could a judge, when the jury comes back with their first note saying we're kind of stuck, say, okay, mistrial time? Yeah, why not? I mean, the Tui Rodriguez or Allen charge is not required. The judge doesn't have to do it. And I've even seen judges not do it because they're like, well, I think it's hopeless, so we're going to give up. But, they at least considered it. They at least considered the Allen charge before saying, it's hopeless, I'm going to give up. So it's not necessarily required that you do any of these particular things, but it might be required that you considered all these particular things. Maybe that's the problem. In 1981, then, Justice Rehnquist noted the court had never overturned a trial court's declaration of mistrial after the jury was unable to reach a verdict on the ground that manifest necessity standard had not been met. That remains true today, nearly 30 years later. Yeah, I mean, okay, fair enough. And then they note Bluford versus Arkansas, which we've noted a lot as well in our discussions. Following Ranko and Bluford, the First Circuit similarly has held trial judges are not required to take specific steps or make specific findings before concluding a jury is deadlocked and unable to reach a verdict. Rather, a judge exercises sound discretion to declare a mistrial based on deadlock so long as they take some step to ensure the jury is truly unable to reach a verdict before discharging it. And that, maybe the judge did that in their prior notes. Maybe the prior notes were sufficient to be like, oh, it's deadlocked now. And maybe that's enough. Maybe the judge was contemplating it during the prior things. Again, the fact that the Allen charge was given puts this on a slightly different posture than if the Allen charge had not been given, when we're trying to figure out what the judge was thinking about, right? If the judge had come back from the first deadlock instruction and been like, I'm just declaring a mistrial now, bring in the jury, let's all go home, right? If they had just done that, that would have perhaps caused a little bit more surprise by the attorneys, because perhaps that seems a little radical as a step. But of course, that didn't happen. The judge had sent the jury back 3 times, the second time with that Tui Rodriguez charge. And again, it's like we kind of all know what's going to happen as a result of that, because we know from cases like Allen and Tui Rodriguez. Basically, we know that once you give that deadlock instruction, it's kind of the last-ditch effort. It's the dynamite charge. This the thing to break the dam. And if it doesn't work, we're all kind of going home. And if we don't all go home, usually the defense gets really mad, because we've covered cases like that before too, to be quite honest. So maybe the consideration is implicit in the other things that happened, or something like that. Or maybe the consideration is implicit because once they sent back the Tui Rodriguez charge, maybe the judge was silently calculating in their own head other options that they never put on the record. Maybe that could be. I mean, fair, to be honest. Thought she gave 2 Allen charges. I've seen it before. I don't know that I've ever seen 2 Allen charges. That would strike me as really weird if there were 2 Allen charges. So I'm not saying it's never happened, but I can't think of any time I've ever seen it. So I'm going to go with probably no, but thank you for the comment anyway in chat. The judge, incidentally, just saying, like, in a somewhat more generalized sense, I'm sending you back for further deliberations does not qualify as an Allen charge. An Allen charge is a little bit more specific than that. So the judge simply saying, I don't think you've given enough consideration, I'm sending you back, does not qualify as an Allen charge. So if that's what you're thinking, that's not an Allen charge. Here, the trial judge more than satisfied the requirement. The jury's first note was delivered to the judge after approximately 19 hours of deliberation over 4 days. You clicked off my initial video because I was biased from the jump. I try really hard not to be biased. I try very, very hard to give an honest, fair, and judicially correct assessment based on the understanding of the law, which isn't necessarily perfect, but I do my best. And it's like, okay, here's the standard of the law. Here's what things seem to be. Here's the best analysis. And then I read a complaint or I read a response, and I'm like, okay, here's where they're sort of making, this is what I typically do on the channel, right? I'm like, okay, here's some points that maybe, here's an idea that perhaps works. I can't necessarily think of everything, despite how smart I am. I like to think I'm pretty smart, but I'm a limited person. But they're making some points. I'm like, okay, maybe there's an idea in here, maybe there's an idea in here. It's what the smart people do. The smart people listen and they think and they take new information and they reevaluate. It's a good thing to do. It's a good thing to do. Here, the trial judge more than satisfied the requirement. It also didn't help, incidentally, in my humble opinion, that the petition was not necessarily as well written as I would have liked personally. I didn't really find Karen's Reed petition to the federal court particularly well written. It was way too lofty and way too aspirational with too many quotes of America is great, yay America, and not enough specifics. I kind of felt like they buried the lead a little bit, but okay, which made it a little bit difficult to understand the importance of the First Circuit case, because I'm not sure Karen Reed's attorneys necessarily made it as clear as they could have. At least in my humble opinion, left something to be desired, but we press on. Anyways, the first jury note was delivered to the judge after approximately 19 hours of deliberation of 4 days. In it, they state that despite our exhaustive review of the evidence and our diligent consideration of all dispute evidence, we've been unable to reach a unanimous verdict. The judge did not rush to declare a mistrial. Instead, she heard from the parties. And even though defense counsel argued that the jury already had exhausted all matters of compromise, all matter of persuasion, and were at an impasse, the judge did not immediately declare a mistrial. She took a measured approach of considering the extent of jury deliberations in view of the trial length, the amount of evidence presented, and the complexity of the issues to be decided. She concluded the deliberations had not been due and thorough, and she instructed the juries in a non-Allen, non-Chewy Rodriguez charge kind of way to give it another shot. The jury then deliberated for another 5 to 6 hours, spanning a Friday afternoon and the following Monday morning, before sending a second note that was noticeably more definitive. The second note said, we find ourselves deeply divided by fundamental differences in our opinions and state of mind, and that the divergence in our views are not rooted in a lack of understanding, but deeply held convictions, and consensus is unattainable. This is one of the best jury notes I've ever read in my life. This is like one of the most, I beseech you, sir, kindly, this is one of the most thorough jury notes I've ever seen in my life. Again, the judge did not race to declare a mistrial. She once more gave the parties an opportunity to be heard. Defense counsel argued the jury was hopelessly deadlocked. Still, the jury did not declare a mistrial. Instead, she gave the Chewy Rodriguez charge, which is also called an Allen charge, except we gave it a different name because we're cool, because we're Massachusetts or something. After nearly 4 hours of additional deliberation, bringing the total to approximately 28 hours, the jury submitted a third note that was even more emphatic. The third note said, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided, stemming from a sincere adherence to individual principles and moral convictions. And further deliberations would be futile and only serve us to force us to compromise these deeply held beliefs. With language like this, I feel like I'm reading a political treatise, right? I feel like I'm reading a political treatise at this point. It's so well written. But that's cool. We have a very well lucid written jury. That's fine. It was only then, after all the steps described above, in light of the tone and content of the jury's final note, that the judge declared a mistrial. In the memorandum of understanding denying the petitioner's motion to dismiss, the trial judge explained she had no doubt, based on the jury's note, that the jury was unable to reach a unanimous verdict. Nothing in the three notes she found indicated agreement on any charges or even an inkling of agreement. Well, yes, I suppose no, but she could have asked, and it doesn't sound like she considered asking. So, that could have been the problem. Yeah. Despite the evident care that went into writing the notes and how articulately they expressed the jury disagreement, it was also clear to the judge from the third note the juries would not consent to continue deliberations. Fair enough, but if you had asked them, whether or not they had any verdicts already done, maybe. Although, we will never know for sure. No one can know for sure what the counterfactual would have been. But it would have genuinely surprised me if the defense had she asked, hey, do you want me to ask for partial verdicts? It would have very much surprised me if the defense had said, yes, that's something we're really interested in, right? Of course, the defense is interested in it now because they know the answer. So they're really interested now, but I have serious reservations they would have been interested then. But of course, she didn't ask, so we'll never know for sure. At that point, the judge was precluded from Massachusetts law from ordering the jury to continue deliberations without consent, which is typically true, of course, of the Allen charge in general. You can't really give the Allen charge and then be like, let's do a second and more exciting Allen charge. Not so much. The Supreme Judicial Court likewise found the jury clearly stated during the deliberations they had not reached a unanimous verdict on any charges and could not do so. The first and second notes provide no indication of partial consensus, and the third note, with repeated references to the charges, plainly implied the opposite. I'm not sure it plainly implied it, but it could be read to say that. That's a valid reading, but I'm not necessarily sure it implied it, but okay. In short, the record before the trial judge suggested a complete deadlock. The trial judge not took some step, but multiple steps to determine the jury was genuinely deadlocked before declaring mistrial. Yes, but the jury being deadlocked, did she have to consider partial verdicts? Or, even if it's like, I don't do partial verdicts, I don't wanna, I don't believe in partial verdicts. But she didn't really say that, not that I'm aware of. She just didn't seem to say that. So at any point maybe she said it at some point during the trial or in the preliminaries. Maybe she said, I just don't really do partial verdicts. But of course, if she had said that, presumably the petition would note that and be like, oh, she had considered partial verdicts by saying it's just not something I do. But presumably she never said that because they're not saying she said it. So probably not. Both the trial judge and the Supreme Judicial Court found the jury was truly unable to reach a verdict. The judge acted well within broad discretion in declaring a mistrial. Exercise of discretion is sound where the judge does not act irresponsibly or irrationally for reasons completely unrelated to the tribal problem which purports to be the basis for the mistrial. The petitioner's argument to the contrary proceeds from a flawed premise. Pointing to the language in Washington that the burden of justifying mistrial rests on the prosecution, which it does, she claims the Supreme Judicial Court improperly shifted the burden on her. The court went on to explain in Washington, however, a deadlocked jury is the type of manifest necessity sufficient to achieve the burden, which of course it is. Indeed, the classic basis for a proper mistrial. True as far as it goes. The question then becomes whether the judge abused a broad discretion in declaring mistrial for that reason, which is exactly the question the Supreme Judicial Court answered. There was no burden shifting. Petitioner maintains the trial judge abused her discretion by failing to consider alternatives to mistrial and to afford defense counsel an opportunity to be heard considering the declaration of mistrial. To begin with, the court in Ranco expressly rejected the proposition. The judge's exercise of sound discretion hinges on whether the judge heard the opinions of the parties about the propriety of the mistrial, considered alternatives to the mistrial, and acted deliberately instead of abruptly. Okay, that is technically correct, is the best kind of correct, but wildly misleading. That is technically correct, is the best kind of correct, but wildly misleading. Yes, the court did say it didn't hinge on that because the court said there is no mechanical rule, right? Manifest necessity is all we got. We've tried, other courts have tried, but we can't do any better. We can't do any better. There is no mechanical rule. Manifest necessity is all we've got. What is it? We're not quite sure. We can't clarify it anymore. That's all we can do, right? And then they laid out, here's some factors that you could consider, including these 3 factors. Now, of course, the fact that there's no mechanical rule means that these 3 factors are not a mechanical rule, because there is no mechanical rule, right? So it can't be the case that merely because you meet or fail all these factors, it necessarily must mean a particular result, right? It can't mean that, because if it did mean that, it would mean there's a mechanical rule, and there's not. But that being the case, like, here's 3 factors we should look at. And, I'm not really sure that the court really did any of those factors with respect to the issue of the mistrial. Did the judge hear the opinions of the parties about the propriety of the mistrial? Not really. Did they consider the alternatives to mistrial? There's no record of that. And did they act deliberately instead of abruptly? The declaration of mistrial itself was a little abrupt. I mean, again, it did come after the deadlock instruction, but, she's not doing really great on 2, possibly 3 of the factors. So are the 3 factors dispositive? No, but it's a bit suggestive. The court cautioned that Washington nowhere established these 3 factors as a constitutional test that determines whether a trial judge has exercised sound discretion in declaring a mistrial, nor could such factors properly be understood as merely an illumination. The court went on to note that although the trial judge in the case could have asked the foreperson additional follow-up questions, granted additional time for further deliberations, or consult with the prosecutor and counsel before acting, and that any of these steps would be appropriate under the circumstances, none of the steps were required under the court's double jeopardy precedent. Okay, we might have to read the Supreme Court case in Renko now to see whether or not that's a fair citation. So we will have to now read the U.S. Supreme Court and see what they've had to opine on the issue, and see whether or not they're faithfully quoting that. So let me post that citation in chat for myself for later. That'll be fun. Okay. The trial judge's purported failure here to do what is not required is not a basis for granting habeas relief. Okay. Even assuming federal law, like Massachusetts law, mandates a judge consider alternatives to a mistrial and afford counsel an opportunity to be heard, the petitioner would still not be entitled to relief. Okay, as described above and as the Supreme Judicial Court found, the judge did consider and pursue such alternatives. Interesting. Yeah, that's interesting. Is that a finding of fact? Is that a statement of fact? It might be. It might be a statement of fact. In which case, the federal court is bound by that. So the Supreme Judicial Court saying, yes, they considered the alternatives, the federal court may be bound by that. Interesting. After the first notes reporting a deadlock, the judge instructed the jury to keep deliberating. Following the second note reporting a deadlock in even stronger terms, she issued the Tui-Rodriguez instruction. It was only when the jury submitted their third report of a deadlock, at which point the judge was statutorily precluded from ordering them to continue deliberations without consent, that the judge declared a mistrial. The petitioner glosses over these alternatives that the judge employed in response to the first and second notes. Yeah, but I mean, it wasn't really like the question in the first and second notes was, should the jury keep deliberating? That was really the only question at that point. I mean, that was explicitly mentioned. The judge never mentioned mistrial really as a possibility. So I'm not sure it was adequately discussed, in the prior hearing. Maybe it was, but it's a little implicit if it is there. She focuses in isolation on the third note and contends the judge, in response to the note, should have inquired pursuant to law as to the existence of any partial verdicts. But the Supreme Judicial Court, in constructing Massachusetts law and the court prior precedents, held the judge is not required to make an additional inquiry into the jury deliberations, including the possibility of partial verdicts, or poll the jury to confirm their deadlock, and had she done so, it would be improperly coercing the verdict. Okay. So that's obviously true as a matter of Massachusetts state law. So She's not required to do it. She's not required to make the inquiry. It's not something she has to do, but it is an option, right? It is an option. Now, you might have to get the jury's consent, and the judge might have just said, how about no? But the fact that there's no explicit discussion on the record could be the problem, right? So yes, the judge could have considered it and then dismissed it out of hand and then say, I'm declaring a mistrial. But, as there is no federal constitutional imperative that the trial judge make these inquiries, I already know what the Supreme Court decision says without reading it. I mean, we can confirm that I'm right if you guys like, but I already know what the Supreme Court decision says now without reading it. I wasn't clear before, but now I know what it says. Now I know what the Supreme Court decision says. The Supreme Court decision says that none of these particular things are required. That's what it says. None of these things are in themselves particularly required. So it's not necessary that the judge necessarily consult with the attorneys. That maybe isn't a required step, right? If the judge had just been opining to themselves from the bench, I got this note and I was considering this option, this option, this option, this option, but it's deadlocked. How about mistrial now? The fact that they didn't consult with the attorneys may be legally sufficient. So I already know what the Supreme Court says. The Supreme Court says none of these are particularly required. But the fact that none of them are particularly required doesn't necessarily mean that you can just skip with them all. All right, any one of them might be missing, but it's not like you can't just do everything. That might be the problem. So there are many potential ways to get to the end, but you might have to do something. Oh, yeah. Okay, and Just Me Gaming in chat gives this reporter's note with respect to this rule, and I'll comment about this again because I think it's an interesting point. Yeah, in the reporter's note to the rule relating to partial verdicts, the reporter's note is written in such a way that seems to say that getting partial verdicts is required. But it's not, though. And the reason I know it's not is because the Massachusetts Supreme Court is, of course, the ultimate judge of Massachusetts state law. And so if that rule meant that partial verdicts were required, then the Massachusetts Supreme Court would have said, bad court, you didn't do the partial verdicts. It's required by the rule. But it's not required by the rule. And the reason I know it's not required by the rule is because the Massachusetts Supreme Court didn't say it was. And that's what the rule means. And the federal court can't change that determination because the federal court can't change the state's level's decision about what its own rules mean. So the rule doesn't mean must. The rule means may. Despite the language in the notes, it means may. Great, moving on. In New York, you have to consult with lawyers. Do you though? You say that, but do you actually, right? This is the thing. Right? Do you actually have to? Right? And maybe it's the case that New York case law does explicitly require it. I'm not saying there's not some New York case that says it. I'm just but in New York they do it. Well, maybe they do it, but do they have to? Is there a case that actually firmly requires it? Is there a case that says that, right? So who knows? Yes, there is. Okay, great. If there's a case in New York that explicitly says it, then fine. Fine. New York can obviously impose it as a matter of its own rules. That's something that New York has the power to do as a matter of its own rules. So if it's explicit, cool. But we're not in New York. We're in Massachusetts. So moving on. As there's no federal constitutional imperative the trial judge make these inquiries, the Supreme Judicial determination that further inquiry was not viable, alternative mistrial as a matter of state law is dispositive. Nor did the trial judge fail to provide defense opportunity an opportunity to be heard. In addition to soliciting counsel's views after the first and second note, the judge found counsel had multiple opportunities to object to declaration of the mistrial. And this is the bigger problem for Karen Reed in the end. This is the bigger problem where she's sitting right now. So the First Circuit decision relating to sufficient consideration of alternatives seems to be pretty good for Karen Reed. However, her counsel had arguably an opportunity to object and sat on their rights to object. And so you can call it waiver, you can call it consent. Either way, it doesn't really matter what label you give it, arose by any other name, right? But the fact that her attorneys didn't object during the 30 seconds while the jury was being brought in, or even potentially while the jury was sitting in the back room, because they're like right over there. We can go get them, right? The fact that there was no objection raised is a real problem for Karen Reed. It is a very real problem. And so the failure to object is a massive problem. Counsel could have objected or at least be asked to hear on the matter, whether it was a request to be heard at the moment or some point before any final decision was made on mistrial. While waiting for the juries to enter the courtroom, especially since the judge had announced to counsel, the jury remained at an impasse. The defense also could have voiced an objection or asked to be heard during subsequent discussion with the judge about status, or even while the juries were still in the courthouse and waiting in the deliberation room for the judge to speak to them. The judge further found that had counsel raised the issue, she would have heard, which, fair enough, because despite the fact that the judge is incredibly hostile to the defense every time they've ever asked to be heard, the judge has heard from them, even if it is to spit in their face. So there is no indication that, like the First Circuit case where that lawyer was being, completely shushed repeatedly over and over and told not to speak and sit down and, shut up. There's nothing like that in the Karen Reed case. So, fair enough. She also made a point to note that defense counsel is no shrinking violet. They never need the judge to inquire whether they had an objection or to be heard, and never refused them an opportunity to be heard in open court or at sidebar, making it difficult to believe the judge, when counsel heard the jury was at impasse for the third time and mistrial is inevitable, at perhaps the most crucial point, counsel would sit silently if they did not consent. Yeah, that's the problem. That's really the problem, especially on a habeas posture. Because you're looking for something clearly established. And anyone who follows this channel when we discuss, for example, qualified immunity, knows just how clearly established has to be. It has to be really clear, super clear. So, yeah, that's a problem. That's a problem. Let's see. Despite several opportunities to do so, defense counsel neither objected nor expressed any dissatisfaction with declaration of mistrial. For these reasons, trial court found non-credible the assertions in petitioner's motion to dismiss the declaration of mistrial was sudden and unexpected. As to that much, I'm pretty sympathetic to the Massachusetts court. It's like, yeah, again, like we all know what the game is once that instruction is given. So to say it was totes unexpected, we were totes surprised though. I'm like, lol, no, you weren't. That's ridiculous. Or defense counsel assertion in his affidavit in support of the motion, they lacked an opportunity to be heard. These findings and credibility determinations, which are binding, fair enough as far as it goes, belie petitioner's claim that counsel was not afforded any meaningful opportunity to be heard. Okay, cool. All right, so I'm going to take just a second and try to answer some of your questions. Let's see what you guys have in chat. Tara asks, question, did some of the jurors ask the foreperson, ask the judge if they can give a partial verdict, make any difference? No, it doesn't make any difference. It doesn't make any difference because, of course, the judge didn't know that, and we can only base error based on what the judge knew or didn't know. So what, the fact that, some members of the jury wanted to do that, the judge had no way of knowing that. So it can't possibly form a basis of the judge's abuse of discretion error. But thank you for the question. Yeah, Tony in chat says, the problem is it wasn't just 30 seconds to argue mistrial. They had plenty of time to consult with her in the time leading up to the last note. Yeah, that's the problem, right? We had no time to consult with our client as to what would happen if the jury was deadlocked. I'm like, are you sure? Because after that deadlock instruction, it's like, we all know what's happening, right? You didn't have time to consult with your client. I kind of think you did. There's not a lot of options left here, man. So there's time to talk about it. Isn't a major problem in the case that the yes/no verdicts were not given in court on the record? Well, that's a problem, but not necessarily the big problem. Because, well, it is a problem, but not necessarily the problem. Because if the judge didn't give sufficient consideration to all the alternatives, then it doesn't really matter that the the judge didn't ask for partial verdicts, because the failure to consider all options would be error. It would be error that would lead to reversal. So we no longer need to know what the jury would have thought. We no longer need to ask that question because it doesn't matter anymore. It doesn't matter now, and it wouldn't also matter then. It wouldn't matter what the jury was going to do, because either way, the judge committed an error that would lead to a bar on prosecution. So if the defense is right, we don't need to ask the jury either, because, there was an error of law and that's sufficient. So that's exciting for the defense if they can get there, but it's a problem. Is this a motion to dismiss? No, this is not a motion to dismiss. This is a habeas petition. It's a collateral attack. Many news articles call it an appeal. Strictly speaking, it's not an appeal. Very technically, it's not an appeal. It's a collateral attack. She's going to federal court in a new lawsuit to try to attack the case from the side. I know, it's exciting, but that's what we do sometimes. It's good times. Yeah. Is it Karen Reed's birthday today? Oh, happy birthday. I'm sorry that you're getting completely screwed by this completely bullshit prosecution. The evidence against you is less than ideal. So, and some of the techniques by the police leave some questions in my mind relating to solo cups and leaf blowers and evidence logs and lab testing protocol and Trooper Paul with a pirouette. Yeah, it's not exactly the most rousing case I've ever seen in my life. Good times. All right. Incidentally, by the way, we do have solo cups available for sale on our merch store. So if you'd like to get your very own solo cup, they are available on our merch store. You might want to buy one. They are cool. And then you can have a solo cup of your own. Not recommended for evidence collection, although it is made of glass. So it would probably be a better evidence collection vehicle than the plastic solo cups, but still not necessarily recommended for that purpose. But you do you. Why is all the evidence not in the federal habeas? It's irrelevant to the issue. We're not here on a sufficiency of the evidence basis. So the reason none of the things I just said are in the habeas is because we're not seeking habeas on the basis of insufficiency of the evidence. We're seeking habeas on the basis that the judge failed to consider their options. So evidentiary problems are not relevant to the immediate legal issue. So they're not mentioned because they're not relevant. What does impounded mean? Impounded just means that it's kept off the docket. It just means it's under seal. They call it impounded for some reason. I don't know. Massachusetts wants to be different. Every other court in the world would just call it being under seal. Massachusetts wants to call it being impounded. I don't know. They have strange and exciting names for things. I don't know. All right, let's press on. Alternatively, the petitioner may be retried on counts 1 and 3 because she consented to the mistrial. This is the bigger problem, is the consent, or waiver, if you prefer. For much the same reason, the trial judge also concluded the counsel's lack of objection constituted consent. Having determined mistrial was manifestly necessary, the Supreme Judicial Court did not reach the issue of consent and declined to do so. Petitioner addresses the issue in a footnote in her memorandum of support of her petition, asserting this court, well, no, it's not just a footnote. It was a little bit more than a footnote. Asserting this court should find that she did not consent because she did not affirmatively did so and did not implicitly consent because she had no opportunity to object. Yeah, I'm not sure about that one, unfortunately. As detailed above, counsel had ample opportunity to object, but neither did so nor even asked to be heard concerning the mistrial declaration. Counsel instead proceeded to schedule a status conference in preparation for the retrial. That is sufficient to permit a finding of implied consent, which implicitly or independently removes any bar to retrialing prosecution, irrespective of manifest necessity, which is true as far as it goes. That is correct, right? You need both. So you need both both that there was not manifest necessity and the defense did not consent. Consent as in many things, is a killer, right? Like if the cops have consent, it pretty much means the search is coming in, right? The cops love consent. It's the reason they're going to ask you if they can search, even if they have a warrant in their hand, almost invariably, right? If they can ask you do you mind if I look around, and you say yes, that's like the cop's favorite thing, because it kills any potential options, any potential errors that might exist. So even with a warrant in hand, they'll usually ask, because consent will doom you every time. So yeah. So it is a problem. The petitioner was not acquitted of any charge because no verdicts of acquittal were returned, announced, and affirmed by the jury. I think that's true insofar as it goes, right? I mean, it's true that, we're not necessarily rigidly locked to the form, but it's got to be something. It's got to be something. So, there wasn't really anything. So, yeah. In determining whether a double jeopardy clause recognizes an event as an acquittal, the question is, given the operation of state law, the jury acted on their view, the prosecution had failed to prove the case. The Supreme Judicial Court's instruction on what constitutes a valid jury verdict under the operation of state law is definitive and binding in the habeas. Almost certainly that's true. Yeah, that's almost certainly true. The fundamental requirements for a jury issuance of a verdict in a criminal case are set forth in the Massachusetts rule. Pursuant to that rule, a valid jury verdict must be unanimous and returned by the jury to the judge in open court. Our case law confirms a criminal verdict is effective only when affirmed by jurors in open court. In other words, the distinction between an informal agreement on verdict and actual return, receipt, and recording is central. Only the latter constitutes a final verdict. We've consistently reaffirmed the longstanding distinction. So, Massachusetts can obviously insist on that as a matter of its own state law, right? Massachusetts can say what the verdict looks like. And so they can say that. And then the only question would be, like, is there any federal law that precludes them from doing it that way? And not as far as I'm aware, no, there's not. So again, well, this issue, I don't really think this issue is the winner. The best one is the other one. This one's more of a toss away argument, but the state wins this argument to be sure. All right, where are we? By the way, for the 851 of you who are currently here, I wouldn't mind very much if you hit the like button. It does really help with the algorithm. The YouTube algorithm doesn't like me sometimes, and I would really appreciate your hitting the like button. Plus, of course, it is only 99 cents a month to join. It's literally as cheap as YouTube will let me make it. I can't make it any cheaper. So you might want to hit that join button, become a member today. You become an uncivilian. You get some cool behind the scenes content. You get to watch me do cooking videos, potentially embarrassing myself while doing so. Gaming streams, recording sessions sometimes, editing sessions sometimes. It's fun. It's fun. And you get some cool emojis. It's good stuff. All right. Here, the verdict did not return, announce, and affirm a final verdict on any charge. There are only open and public unanimous acts where the statement to the judge they were unable to reach a unanimous verdict or attain consensus remained at impasse and were starkly divided on whether the evidence was sufficient to establish element of the charges. Why they are in an impasse as to that is a whole nother set of problems, right? I mean, I just don't really understand why 8 members apparently were of the view that she's guilty of manslaughter. How? And I still haven't watched that interview with that juror. I haven't watched the interview with the juror, but I heard it got really depressing with the juror saying, like, we didn't really consider the defense's experts. We don't really care, blah, blah, blah. So I don't really know why 8 people thought guilty. The only thing that comes to mind is I've said before that there's basically a 5% base chance, no matter what happens, the jury will convict just because the defendant is sitting at defense table. Right? If not guilty, why guilty shaped, basically. Right? It's like, we got to prosecute somebody. We got to convict somebody. That person's convenient. You know? Surely the police would never arrest anyone who is innocent. Surely the police don't make mistakes. Even if the jury deadlock pertains specifically to count 2, their notes made no such distinction, nor they indicate a verdict would be returned as required by the rules. As such, the trial judge in the Supreme Judicial Court, I still want to know why they're called the Supreme Judicial Court, not the Supreme Court. Are they concerned that we'll confuse them with the Supreme Non-Judicial Court? What is the Supreme Non-Judicial Court? I have questions. Correctly ruling the petitioner was not acquitted of any charges. The requirement of an open and public verdict announced and affirmed in court is far more than a mere formality, though the petitioner argues otherwise. Public affirmation open court provides safeguards against mistake. Thank you very much, Alert Systems 1, for becoming an uncivilian. I appreciate it. Okay. Indeed, under state law, even jurors agree upon a verdict, fill out a verdict slip, and walk into a courtroom. Any juror remains free to change their mind before the verdict is affirmed and recorded. Fair enough, right? And I don't know that we've ever seen it, but, well, no, we kind of did see it, actually. We saw it. We saw it in that one Washington case that we did or reviewed. You guys probably didn't see it because we just watched the jury verdict get returned. But we watched a case, I'm pretty sure it was Washington State, where 6-member jury, because it's a misdemeanor. The guy was accused, I think, of misconduct, disorderly behavior essentially on a bus. I think he was accused essentially of disorderly conduct on a bus. And the jury came back, they were like, not guilty. And then the judge asked him, okay, they asked him, like, is this your verdict? Is this the verdict of everyone? And the juror said, we have to be unanimous. And then they said, the clerk told us we didn't have to be unanimous. 4-2 is good enough. Lol. Yeah, what do you mean we have to be unanimous? We all have to agree? Yes, you do. Yes, you do. Federal precedent does not demand a different result here, as Bluford has made clear. Bluford is a pretty good case for the prosecution, I'm not going to lie. There, the foreperson disclosed to the judge that the jury had voted unanimously against guilt on 2 of the offenses, were deadlocked on the 3rd, and not voted on the 4th. The jury continued to deliberate, later reporting to the judge they did not reach a verdict, and the judge declared a mistrial. Defendant in that case similarly argued acquittal is a matter of substance, not form, and there had been actually acquitted of 2 offenses based on the foreperson's earlier report of the unanimous votes. The Supreme Court expressed no endorsement of this premise of substance, not form, and instead rejected the argument on its own terms. So the jury came back in that case, right? In Bluford, they said, we're not guilty as to the capital, was it capital murder? I'm pretty sure it was capital murder. Doesn't really matter. We're not guilty as to the murder charge. We're a little unclear on some of these other charges, though. Judge said, give it another go and come back. And then the jury's like, we can't make up our mind on anything. Right? That's a bad moment for the defendant, right? That's a bad moment. That's snatching that not guilty verdict right out of your hands, man. That sucks. U.S. Supreme Court said that was okay, though. So, well, that's the end of that game. So, that's fine. It's called the Supreme Judicial Court because the legislature is called the General Court. The legislature is called the General Court. Okay, follow-up question. Why is the legislature called the General Court? The foreperson's report in Bluford was not a final resolution of anything the court held because the jurors continued to deliberate after that report and were therefore free to revisit their prior votes and change their mind. The court further noted it'd be unjustified to assume the reported votes did not change, given the possibility even a single juror could have rethought the positions on the offenses. All legislatures were courts. Okay. Neat. The petitioner argues Bluford is factually distinguishable from the instant case based on the flawed assumption that purported jury statements at issue here reflect the jury's position at the end of deliberations. For one thing, a closer reading of the statements reveals they do not identify at what point during the 5 days of deliberations a jury allegedly reached unanimous verdicts. I mean, I suppose that's true as far as a hyper exacting reading of the thing goes. They therefore do not foreclose the possibility that the supposed unanimity perceived by some jurors was based on a preliminary discussion or straw poll conducted early in or at the start of deliberations, the very scenario cited by the Supreme Court. I like that. That's a very creative argument. I have to give the Commonwealth bonus points for that one for sheer creativity. It's like, okay, these notes from the jurors that said they're unanimous, they didn't say when. They didn't say when they were unanimous. It could have been any time. The juries are talking about their experience and saying, oh, the jury was unanimous. But the notes didn't say when they were unanimous. It could have been any time. We don't know it reflects their final thoughts. I like that argument. +1 creativity point. +1 creativity lawyer point for you. That's a good one. For another thing, the purport statements also do not and cannot establish that none of the 12 jurors would have changed their mind had the jury gone through the process of returning and forming a verdict in open court and solemnity that attends the occasion. In rendering a verdict that communicates the true finality and unanimity of declarations, and because the jury did not publicly affirm the petitioner was not guilty, there is no acquittal barring retrial. The petitioner's requested post-trial inquiry would require delving into the jury's deliberation and impermissible subject. I'm not sure that's necessarily true. I'm also not sure it's as simple as the defendant wants to make it. And of course, it doesn't matter, of course, unless it has some legal operation. So there's no reason to ask the jury what they thought unless it legally matters, of course. And since at the moment it doesn't legally matter, there's no reason to ask. But, we can read this for a point. Petitioner contends in the alternative she's entitled to a post-trial inquiry of the jurors. The Supreme Judicial Court rightly rejected the contention, concluding the requested inquiry would contravene Massachusetts law and its prohibition on probating the content of jury deliberations. I'm not sure that's really the content, but fine. The court emphasized that maintaining the secrecy of those deliberations is a bedrock of the system, which not only prevents jury tampering, but also upholds the finality of jury verdicts and fosters confidence in the judicial process. I'd ask how much confidence you guys have in the judicial process right now, but I think I know the answer. It's lots, right? You have lots of confidence in the system right now, right? Your confidence in the system couldn't be any higher, right? Right? Yeah. Probing secret deliberation to determine whether jurors may have privately agreed on a verdict they never returned would undermine these fundamental principles. Federal law is not to the contrary and does not compel such an inquiry made notwithstanding state law. And then they compare federal rules of evidence, which, has nothing really to do with anything, comparing the Massachusetts rules of evidence, which also don't really have anything to do with anything. The Supreme Court has repeatedly affirmed the common law anti-impeachment principle, which is embodied in the federal rules of evidence. The federal rules of evidence are also not material at the moment. As noted, it provides that jurors may not be asked to impeach a verdict by testifying about matters internal to deliberation. And then they cite a U.S. Supreme Court case, juror may not testify to remarks made by another juror during deliberations which show the juror at issue lied during voir dire. Interesting case. See also Tanner v. United States. Anti-impeachment rule bars jury testimony about consumption of drugs and alcohol by members of the jury during deliberation. So if the jury is back in the jury room doing lines of cocaine and they convict you, that's just unfortunate. Which drug is best for jury deliberations? That's a good question that I didn't think I needed to know the answer to. Which drug goes best with jury deliberations? Is it Molly? Is it cocaine? Is it Whippets? What drug pairs with jury deliberations? Speed, acid, cool. Xanax, Poth. The requested inquiry would necessarily entail delving into the jury's subjective reasoning and deliberative content. Although I don't know that that's necessarily true, but okay. But if they ask for a Ouija board, that is different. That is in fact different because that case actually happened. That is a great case. I love that case so much with the Ouija board. That was great. So a jury is hearing a murder case. You already know where this is going, right? Before I finish the story, right? A jury is hearing a murder case and they're trying to figure out whether or not the defendant did the murder. So they decide to break out a Ouija board in the jury deliberation room and ask the murderer or ask the murdered whether or not the defendant did the murdering. Were you killed by this guy? Court didn't like that one. Court overturned that one. They didn't really like the ask the decedent whether or not he was murdered by the defendant. They didn't really like that one. They thought that was a step much. The judge found statements directly contradicted the jury's note during deliberations, including the final note expressing stark divided elements of the charges. The Supreme Judicial Court also found statements were inconsistent with and contradicted by their prior notes. No, they didn't. Did I get the story wrong? Which part of the story did I make a mistake on? Which story did I make? Which part of the story did I make a mistake on? Jeffrey, do you know the case? Which part did I make a mistake on? I'll wait a second while he's typing in chat to see if I can get corrected on the facts on this one. I don't mind correction on facts like that. All right, I'll just spot chat and see if Jeffrey types and corrects me. Well, we'll see. Let's see. That's okay. The petitioner argues, as does the state court, as a partial verdict is only valid when announced. How's the judge not required to make the inquiry? Because if the judge doesn't ask, it's not announced. I mean, that's clear enough as far as it goes. Oh, you're right. I couldn't believe it. Yeah. No. Yeah. Yeah. So I try not to just make up shit. I try really hard not to make up shit. It's like, yeah, the Ouija board with contacting the dead guy to figure out if the defendant murdered him. Yeah, that happened. Yeah, that it's like, no, it didn't. I'm like, yeah, it definitely did. Yeah, it definitely did. The petitioner argues, as did the state court, that jury reference to the charges can be readily understood to mean count two and its lesser included. That's not the more natural and straightforward reading. It's not what the trial judge and Supreme Judicial Court found it to mean, nor is it consistent with petitioner's petition at trial. But more importantly, it does not matter. Can we get ChatGPT to determine if they're guilty? Holy shit. It's going to happen. It's going to happen someday. I don't know when, particularly if the jury's not sequestered. It's definitely going to happen. Someone is going to feed in a trial to ChatGPT and ask where the defendant is guilty. I look forward to that court case. I don't know when it's going to happen, but it's totally going to happen. It's totally going to happen. So we can all look forward to that court case someday. That will be fun. Assuming it hasn't already happened, incidentally, and no one's found out about it yet. So I'm not putting off the probability that it's already happened and just no one's figured it out yet. But more importantly, it does not matter what petitioner now in hindsight claims reference to the charges might mean. It matters what the jury meant at the time and why they said it. And that cannot be determined without inquiry into thinking and deliberations. Further undermining petitioner's assertion of some form of finality is inconsistent even among the jurors who are said to have made statements after the trial. For example, according to juror C, they were unanimous only as to second-degree murder, and the remaining charges what they were hung on. Such statements do not reflect on unanimity on counts 1 and 3. Well, yeah, but still, like, even then they were, even according to you, that's not fair. That's bad pool, bad prosecutor. So that one only said, oh, we were unanimous. Well, they didn't say they were unanimous as to the leaving the scene, the accident one. Yeah, but they still said they were unanimous as to the murder charge. So that's something. But that's a bad one. -1 lawyer point. You don't get a cookie. Apparently, even 5 report jurors saying nothing of the 7 jurors were of one mind. Well, all 5 jurors agree as to count 1, so I mean, there's that, at least that much. These and other discrepancies would need to be reconciled to establish with any confidence whether in fact or to what extent any unanimity must have been reached. That would require an impermissible inquiry into the deliberative process. I don't know that that's true. Simply, were you unanimous at the end, and what is your verdict? Although I don't know what happens if they don't agree. That's the thing, right? That's the real problem. Right. So if we did do this hypothetically and we asked all 12 jurors, which we'd have to do, we'd have to ask all 12 jurors, right? Were you unanimous at the end? And if so, what was your verdict as to any of these counts? What happens if one of the jurors says no? What do we do then? Right? What do we do then? Right? I don't know. So that cannot disclose where they truly stood, and their agreement was merely tentative and may not be in their final position depending on the resolution of other charges, the jury's further discussion of evidence, or some reason without intruding into the hard deliberations. Additional considerations mitigate against the requested inquiry. Jurors questioned at this point more than 7 months after they were discharged may feel pressure to provide responses they believe will minimize the risk of being harmed or harassed, which is not an invalid consideration, although that can be factored into the questioning. Because there have been circumstances where years, even decades, I think, in some cases have passed when the jury's been brought back in to figure out whether or not there was a problem. And so, yeah, the jury's changing a mind or their recollection or pressure put onto them is fair, but that can be dealt with as an evidentiary matter. That's a question of fact, right? That's a question of when the jury is saying this, are they reliable? All right. So hypothetically, even if all 12 members said, we were unanimous. Hypothetically, of course, depending on what they said or how they said it, the judge could simply say, well, I find them non-credible and I don't believe it. And, that would be that. So that's fine. Is it bad that I have some of Kurt's videos favored because when he gets pissed, I find it hilarious? Maybe, but I'm happy that my pain causes you joy anyway. People associated with this case have been charged criminally with witness intimidation. Individuals have also expressed outrage at the jurors and sought to identify them and release their personal information. My outrage is that 8 people can apparently be super dumb. That is my outrage. 8 people are dumb. 8 people are totes dumb. I have apparently grossly overestimated the intelligence of the average reasonable juror. That's apparently my problem. One of the jurors said they feared for their personal safety and that of their family, and they worry they'll be subject to harassment or even physical harm because of what they did or did not do in the jury and its outcome. Several of the poor jurors wish to remain anonymous. In view of these circumstances, a yes-no question may not capture a jury's nuanced views or concerns or lead to reliable or accurate understanding, which, is not completely invalid concern, to be quite honest. Allowing such inquiry raises forward-looking concerns as well. The proper evidence of decision of the jury is a verdict returned by open oath and affirmation. It's essential to freedom, blah, blah, blah. If jurors' deliberations are allowed to become the subject of post-trial inquiry because of purported statements like those here, future jurors may be hesitant to express their views fully and honestly during deliberations. It may also be more difficult to find jurors willing to serve, both in the retrial and here, where jurors know their service may not end when the trial ends, but could subject them to further inconvenience, embarrassment, or harassment. For the reasons above, we should deny. Respectfully submitted, the court, by its attorney, the Attorney General. Exciting. So, yeah. Now let's take a look at this U.S. Supreme Court case, because I'm pretty sure I know what it says already, but we'll read it anyway. And we'll go from there. You guys having fun? Are you fun? How many of you are cupcakes? How many of you are visiting me from Melanie Little's chat? We love cupcakes. If you're a cupcake, please let me know if you're cupcake-dom in the chat. We would love to say that we appreciate you being here. Incidentally, by the way, Melanie and I are looking at being on stream tomorrow. So hopefully that will pan out. That'll be fun. You're a law nerd? We love law nerds too. Is this the right case? Oh, it's at 779. That's why. Okay. I need to do a find real fast and find the citation. Maybe we should add a cupcake to the list of emojis in honor of Melanie. It's actually not the worst idea I've ever had. Maybe we could have an emoji that represents like each of our favorite creators. That's not a bad idea. Maybe we'll do that. Maybe we'll add some emojis for other creators. That can be fun. All right, let's see what's going on in this case. All right. I hate when I have to readjust margins. Margins. Always something, man. Always something. All right. We turn our attention briefly to the case of Renico versus Lett, U.S. Supreme Court, 2010, which says the following. All right. From jury selection to jury instructions in a Michigan court, Respondent Lett's first trial for first-degree murder took less than 9 hours. I mean, wow. I mean, I'm not saying it can't be done, but wow. I mean, the case in Karen Reed took, what was it, like 8 weeks for a second-degree murder. Michigan here is just speed running the whole thing. Michigan here is speed running. We're going to do we're going to do the entire, including jury selection, including jury instruction, including jury selection and jury instructions, right? The whole process, including jury selection and jury instructions and the entire trial. We're going to do the whole thing for first-degree murder in 9 hours. Wow. That is a speedy court, man. That is a speedy court. Outstanding. During the approximately 4 hours of deliberation, which is now half the length of the trial, the jury sent the trial judge 7 notes, including what would happen if the jury could not agree. The judge called the jury and the attorneys into the courtroom and questioned the foreperson, who said the jury was unable to reach a unanimous verdict. The judge then declared a mistrial, dismissing the jury and scheduling a new trial. At the second trial, after deliberating for only 3 hours and 15 minutes, a new jury found him guilty of second-degree murder. On appeal, Lett argued that because the judge in the first trial had announced a mistrial without any manifest necessity, the double jeopardy clause barred the state from trying him a second time. Agreeing, the Michigan Court of Appeals reversed. The Michigan Supreme Court reversed that. It concluded under United States v. Perez, a defendant may be retried following discharge of a deadlocked jury, so long as the trial court exercises sound discretion in concluding the jury was deadlocked and there was manifest necessity for the mistrial. And an appellate court must generally defer to the trial judge's determination a deadlock has been reached. It then found the judge at Levitt's first trial had not abused discretion in declaring a mistrial, observing that the jury had deliberated a sufficient amount of time following a short, non-complex first-degree murder trial. The jury had, it's nice to know that there are such things as simple, non-complex first-degree murder trials. I mean, I guess. I mean, maybe it was just really clear. Maybe it was just super duper clear. Maybe we found him in the decedent's blood, with the knife in his hand, saying I killed him. Maybe with a signed confession. I don't know. Maybe it's just really simple. I don't know, but wow. Okay. Anyways, The jury had sent several notes, including one to indicate heated discussions, and the foreperson stated the jury could not reach a verdict. In Lett's federal habeas petition, he contended Michigan's Supreme Court rejection of his double jeopardy claim was an unreasonable application of clearly established federal law, which, by the way, of course, as I mentioned, is the standard. Clearly established federal law is the standard on a habeas, which is a big problem in any habeas because clearly established has to be pretty damn clear, unfortunately. And thus was not barred by the Anti-Terrorism and Effective Death Penalty Act from obtaining relief. The district court granted the writ and the Sixth Circuit affirmed. So the district court said there was a violation of federal law. The Sixth Circuit said there was a violation of federal law. However, the U.S. Supreme Court said not so much. Because the Michigan Supreme Court's decision in the case was not unreasonable under the Anti-Terrorism and Effective Death Penalty Act, the Sixth Circuit erred in granting Lett's habeas relief. Oh, that makes a lot more sense. Oh, it's the Sixth Circuit. Oh, that makes sense. Oh, yeah. For a long time, and I'm not sure whether or not this is still true, but for a really long time, the Sixth Circuit was like, you get a habeas, you get a habeas, you get a habeas. Everyone gets a habeas. I'm not sure what was particularly up the Sixth Circuit's butthole, but they seem to think for a long time that everything is habeas. All the things are habeas. And the Supreme Court has had to reverse them on more than a few occasions. That like, no, not all the things are habeas, kind of stop doing it. But the Sixth Circuit, for some reason, seems to really like the habeas. So I don't know, man. That's just how they roll over there. So I'm not surprised the U.S. Supreme Court is reversing the Sixth Circuit because it's the Sixth Circuit on a habeas. That makes total sense. The question under the Anti-Terrorism and Effective Death Penalty Act is where the Michigan Supreme Court's determination was an unreasonable application of, and again, here are the key words, clearly established federal law, not whether it was merely incorrect application of that law. Clearly established federal law. That's the habeas posture. It's really hard. It's really hard. The ADEPA imposes a highly deferential standard for evaluating state court rulings and demands they be given the benefit of the doubt. Here, the clearly established federal law is largely undisputed. When a judge discharges a jury on the grounds a jury cannot reach a verdict, the double jeopardy clause does not bar a new trial for the defendant before a new jury. Trial judges may declare a mistrial when, in their opinion, taking all circumstances into consideration, there is manifest necessity for doing so. That is a high degree of necessity. The decision whether to grant a mistrial is reserved to broad discretion of the trial judge, and discretion to declare a mistrial for deadlocking a jury is accorded great deference by a reviewing court, although the deference is not absolute. Yeah, I mean, it's just abuse of discretion analysis, which is, very differential. This court has expressly declined to require mechanical application of any rigid formula. Where a trial judge decides to declare a mistrial due to a jury deadlock and explicitly held the judge is not required to make explicit findings of manifest necessity or articulate on the record all the factors informing their discretion. Thank you very much, MS Julius FL for $20. That's very nice. Thank you for the super chats. Yeah, so the judge is not required to make findings or articulate on the record their reasons. We'll just assume their reasons. On an abuse of discretion analysis, by the way, that's pretty typical. We'll just assume their reasons. We'll assume any reason that makes any sense, right? It's only when it doesn't make any sense that we're going to reverse it. So that's fair enough as far as it goes. So the trial judge is not necessarily required to make its reasoning explicit. The court has never required a judge in these circumstances to force the jury to deliberate for a minimum time, to question the jurors individually, to consult with counsel, to supplement supplemental jury instructions, or consider any other means of breaking an impasse. So none of these things are necessarily required. None of these things are necessarily required. Right? So their absence doesn't necessarily mean it's a problem. Moreover, the legal standard applied by the Michigan Supreme Court is a general one, whether there's abuse of broad discretion reserved to the trial judge. Because ADEPA authorizes a federal court to grant relief only when a state's court's application of federal law is unreasonable, it follows the more general rule at issue and thus greater potential for unreasoned disagreement among fair-minded judges the more leeway state courts have in reaching outcomes in case-by-case determinations. The Michigan Supreme Court application involved a relatively straightforward application of long-standing precedent. The state court cited this court's double jeopardy clauses, applying those precedents to particular facts before and finding no abuse of discretion in light of the length of deliberations following the short, uncomplicated trial. The juror notes to the judge and the fact the four-person stayed, the jury cannot reach a verdict. If those factors look familiar, those are factors that would favor the Commonwealth in our current case. So, the Commonwealth does have a trump card, right? The Karen Reed has a First Circuit case. It's like, I've got better. I've got U.S. Supreme Court case. Now, they're not directly contradictory because there's no mechanical rule. So they're not directly contradictory, but, they've got better language from a better court. So, It was thus unreasonable for the court to determine trial judge had exercised sound discretion. It was thus reasonable for the court to determine trial judge had exercised sound discretion declaring mistrial. The Sixth Circuit concluded otherwise because it disagreed with the inferences that the Michigan Supreme Court had drawn from the facts. The circuit court's interpretation is not implausible, but other reasonable interpretations are also possible. It was not also objectively unreasonable for the Michigan Supreme Court to conclude the trial judge's exercise discretion was sound, both in light of what happened and the fact the relevant legal standard is general, to which there's no plainly correct or incorrect answer. Yeah, that doesn't really help for Karen Reed at all. That doesn't really help. The Sixth Circuit failed to grant the Michigan court's dual layers of deference required by ADEPA and this court's double jeopardy precedent. The Sixth Circuit also erred in relying on its own determinate decision for the proposition that Arizona versus Washington sets forth three specific factors that determine whether a judge exercised sound discretion. Because Fulton does not constitute clearly established law as determined by the U.S. Supreme Court, because it's the Sixth Circuit's own decision, right? It's the Sixth Circuit's own decision, so it's not determined by the Supreme Court. Failure to apply it does not independently authorize habeas relief under ADEPA. Nor can Fulton be understood to merely illuminate this court's decision in Washington, as Washington did not set forth any test to determine whether a trial judge has exercised discretion. The court does not deny the trial judge in the case could have been more thorough before declaring a mistrial. Nonetheless, the steps the Sixth Circuit thought she should have taken were not required, either by this court's double jeopardy precedent or by extension under ADEPA. In a 6-3 decision by the U.S. Supreme Court. Cool. So, clearly established by the U.S. Supreme Court on a habeas. Yeah. So actually, I now have to radically decrease Karen Reed's odds. Right? I have to radically decrease Karen Reed's odds. Because the problem is not only does it have to be clearly established under federal law, it has to be clearly established by the U.S. Supreme Court specifically. Because it's very, very limited. And so I failed to factor that into my analysis when I was doing the earlier review. See, in that First Circuit case, that was the First Circuit reviewing a federal district court. That was a direct review. So that's binding precedent in federal courts. So a federal court has to do that. But since that case obviously wasn't created by the U.S. Supreme Court, it does not create clearly established law by the U.S. Supreme Court under ADEPA. So, therefore, Therefore, the First Circuit case is inapplicable. The First Circuit case is inapplicable because of U.S. Supreme Court precedent. So her odds just basically, I think her odds just kind of basically went back down to zero, basically. That sucks. Yeah, that sucks. Yeah. So, yeah. So her odds just kind of went back down to zero because of ADEPA. So, yeah. Any other questions? You have other questions? Why didn't the defense mention jury tampering? How do they explain fanning? They can't. Well, I'm not sure that they can't, but they didn't raise the issue, so I'm not sure. Yeah, I'm not necessarily. They didn't go to. Okay, I'm actually not 100% sure the defense can, because I'm not even sure in their petition to the state Supreme Court they mentioned Fanning or anything about Fanning with the overview of the jury. They didn't mention any of those issues, right? Their petition to the Supreme Judicial Court of Massachusetts was based on these jury notes and the jury deliberations and what the jury thought. They didn't mention Fanning or Fanning's overview of the court system or anything like that. So those issues are not live in this proceeding, right? Because we're on a collateral attack relating to those things, and those issues were not brought up to the Massachusetts State Court. So we're in review of the Massachusetts State Court Division, although review is not quite the right word, but whatever. So we're stuck with that posture. So those issues are not relevant to our immediate issue. The issues relating to Fanning and his bias and his fact that he should have never overseen the jury, those issues are irrelevant to our current legal issues because that's not the posture of the case. Yeah, this is a habeas petition, not an appeal. Yeah, strictly speaking, it's not an appeal. Yeah, it's a collateral attack. Yeah. Do I mind going over the concept of reasonable doubt? Well, the best explanation I ever heard of reasonable doubt, although I'm not sure how good it is these days, but the best explanation I ever heard of reasonable doubt was that reasonable doubt is the decisions that we use, is the level of confidence that we would need in our most serious personal affairs, right? The classic example of which historically was the decision to get married, right? The decision to get married is, at least in principle, supposed to be a fairly consequential decision, right? So you should be pretty sure about who you're going to get married. Of course, these days with no-fault divorce, and a third of marriages ending in divorce, a third of first-time marriages ending in divorce, I'm not necessarily sure the marriage example necessarily is the best example anymore, but that was the historical example, right? Decisions of that magnitude. How sure would you have to be to, have a child? Also not sure how applicable that is. How sure would you have to be to get married? How sure would you have to be to, I don't know, move to a different state to take a new job, right? Something like that maybe is beyond a reasonable doubt. So, yeah, that's kind of what it means. Yeah, marriage is a terrible comparison. It might have been less terrible a comparison when there wasn't no-fault divorce. No-fault divorce is a relatively modern invention. It was started by Reagan, ironically enough, in California. So no-fault divorce has only been a thing for 40 years, depending on what state you're in. New York only wound up recognizing no-fault divorce like 10 years ago or something, if that. They were the last holdout, which is kind of funny. I think New York was the last holdout for no-fault divorce, but they gave up about 8 years ago, something like that. So back when you weren't able to get divorced, I guess you had to be more confident. What else can I answer for you relating to this? Or anything else relating to Karen Read? Or I suppose other topics of consideration. Because we're at the end of the chat, we can open it up to other legal issues or things of concern, since, we're kind of just hanging out now, if you want. I'm still a romantic, My parents have been married all their life. They've been married for 53 years, I think, at this point. I still have hope of finding the one and staying married to her forever. I have hope. I have dreams. Did I watch the psychic reading of Karen Reed? No. Is the habeas impounded? No, it's not. It's on the public docket. What I think the odds of any of your lawyers getting kicked off the case, it seems like they're teeing up something. It sounds like the judge is teeing up something. Whether that's kicking off the lawyer or preventing ARCA from testifying, she seems to be teeing up something. I think the odds are pretty decent she's going to do something. What that is, I don't know. We'll see. Did I watch oral arguments at the Supreme Court today? No, I didn't watch them, but I heard about them. They were arguing about a white woman who is discriminated against on the basis of race. And it seems like the Supreme Court is about 9-0 at the moment, based on people's discussion, that basically it's the same standard it would be for anyone else of any other race. There's no particular special burden that because you're a member of the majority. So yeah, if you want to argue that you're discriminated on the basis of race and you're white, it's exactly the same as if you're discriminated on the basis of black or race and you're black. So that seems to be where the Supreme Court seems to be going. It seems like it's going to be 9-0. So yeah. Does my mic have a mark? Yeah, my mic has a little plate on there to have the logo. It's nice. I like the logo. I like the plate. It's nice. Yeah, it's a custom black back plate. It's nice. It looks great. It was like $20 or $25 or something, which looks pretty badass. So okay, looked good. The case is disgusting. The evidentiary issues are really problematic. I mean, I don't really know the truth of what happened to Karen Reed, and to some degree, I don't need to know or care, right? It's like, I don't know what happened to Karen Reed, and strictly speaking, I don't need to know, right? Within the context of Commonwealth versus Karen Reed, the only question I need to decide is whether there's proof beyond a reasonable doubt, right? I don't need to know what happened. What do you think happened to Karen Reed? I don't know. What I do think is that the state didn't come anywhere even remotely close to proof beyond a reasonable doubt, and I think their case is laughable and probably worthy of jokes and such. Did I see the impound motion filed today by the Commonwealth and ARCA? Not particularly, but it doesn't surprise me necessarily because there's some sort of federal protective order relating to this. And so some of the material may need to be kept under seal because of the nature of whatever. So the fact that there's things under seal relating to ARCA doesn't particularly surprise me. Do I think Hank believes Karen's guilty? Well, I hope he does to some degree because, I mean, he's supposed to prosecute cases that, he because he's the prosecutor, he's supposed to take cases that, he believes the defendant's guilty. So I hope he believes it. What type of juror would I be looking for? Someone with a brain in their head, I guess, would be nice. Someone with a brain in their head. All right, guys, I guess I'm going to go ahead and sign off for now. I've enjoyed our time together. It's been fun. I'm sorry things for Karen Reed have turned out worse, but yeah, the ADEPA bar here is a real problem. Even if the First Circuit case law was applicable, which it probably isn't in this context because of ADEPA, even if it were applicable, she would still not be on the right side of the issue. So her odds basically went down to zero. I don't see it. I don't see it. So that sucks. So Yeah, that sucks. Maybe something will change my mind again and it'll get better again. One can only hope. I've been on Civil Law. Until later, my friends, I hope all is well. Cheers for now, my friends, and goodbye.